These takedown notices are in violation of plaintiff's rights. Alex was a contributor to a larger audiovisual work under written contract and with an express work for hire clause. Plaintiff's video games and related content are therefore entirely plaintiff's property. Hello everyone, I'm Leonard French, your favorite copyright attorney, and I'm here back with an update in the Alex Mauer lawsuit. It's now become a lawsuit. I filed a lawsuit against her. And I thought we'd make a video over what the claims are and what our response is going to be and what the community can expect. I thought we'd also give an update to the GoFundMe campaign, and I thought we'd talk about a very important negotiation tool that I'm trying to use here that may have failed, but then again is always a tool that you want to continue to use throughout negotiations, and litigation is basically just one big formal court-sponsored negotiation until you get to the trial when it's no longer really much of a negotiation. So let's get started. Here is the complaint that I filed, or rather, this is the amended complaint that I filed a week later on July 7th, last Friday. The amended complaint is pretty much the same as the original complaint, and I'll go over what that was all about actually very shortly here because it's literally the first 2 lines of the document. So, what did we file? Well, I filed a complaint in the U.S. District Court for the Eastern District of Pennsylvania. The case was assigned to Judge Burl M. Schiller. Now, this is the first amended complaint, and you can see right away here why I amended it. It's a complaint amended under Rule 15, which allows amended complaints, and it's under Section C1C, which allows me to make corrections to a defendant's name. I also added the verification of Plaintiff Don Thacker, and I'll explain more about that later. Don Thacker is an artist with a dream he's had since he was 9 years old. A dream of creating a retro shooter video game franchise he calls Starmazer. In January of 2015, Don's company Imagos Softworks began a successful crowdfunding campaign raising $193,566 to help fund development of the game. Don's dream was coming true. Then in March of 2015, he hired Alex Mauer to create the music and sound for the game. Alex is a skilled musician who is known for her talent at creating a retro style of video game sound and music, reminiscent of the arcades, consoles, and computers of the 1980s. Throughout 2015 and much of 2016, development progressed, including on Alex's music and sound contributions. But, at some point, Alex's behavior began to change. Alex requested time off for personal and medical reasons, and it was granted. Don offered myriad support to Alex, hoping that Alex would improve and return to the team. Eventually, though, Alex voluntarily left the development team. Then, suddenly, Alex became demanding. Alex claimed that she wasn't paid and that she had rights to Starmazer and others of plaintiff's works. Don tried to resolve the matter, making several offers to Alex. Alex didn't seem interested in any resolution whatsoever. Alex made the dispute known to plaintiff's business associates, damaging their relationships. Alex persisted in causing turmoil and upset, eventually causing financiers to place funds on hold, further causing the rest of plaintiff's development team to also place development on hold in December of 2016. Don continued to try and find a private resolution with Alex. In June of 2017, Alex began issuing numerous copyright takedown notices under the Digital Millennium Copyright Act, claiming ownership to plaintiff's games and related video and audio content. To date, over 70 items have received takedowns. As a result, Starmazer itself and related video content reviewing and playing Starmazer has been completely removed from the internet, including from popular sites like YouTube and Steam. These takedown notices are in violation of plaintiff's rights. Alex was a contributor to a larger audiovisual work under written contract and with an express work for hire clause. Plaintiff's video games and related content are therefore entirely plaintiff's property. Plaintiffs and other non-parties are currently being damaged by defendants' illegitimate copyright claims and takedown notices. Some of this damage is irreparable. Some of the irreparable damage is severe. Plaintiffs bring this action primarily to adjudicate their rights to the Starmazer franchise so that they may continue to pursue their dreams. Introduction: this matter arises primarily under the United States Copyright Act. Defendant has asserted and continues to assert numerous copyright claims on works owned by plaintiffs. Defendants' illegitimate claims have resulted in plaintiffs' works being removed from online sales and marketing platforms, causing irreparable harm as well as severe monetary damage to plaintiffs. This court has subject matter jurisdiction pursuant to federal question jurisdiction and copyright, which is a federal question. This court has supplemental jurisdiction over the related claims based on Pennsylvania law pursuant to 28 U.S.C. 1367, which allows me to include state claims, related state claims. Venue is proper in this district because the defendant is believed to reside in this district. Plaintiff, Imagos Films, is a limited liability company formed under the laws of the state of Washington and doing business as Imagos Softworks, hereinafter just Imagos. Plaintiff Don Thacker is an individual residing in the state of Washington and a co-owner of Imagos Films. Defendant is Alex Thomas Maurer and an individual believed to reside here in this district. Since at least 2010, defendant has worked on and off as an independent contractor for plaintiffs Don Thacker and Imagos. Since at least 2010, defendant has always worked in a work-for-hire arrangement with Imagos or Don. Since March of 2015, defendant has worked on plaintiff's Starmazer franchise under a written agreement that was executed by Imagos and defendant. This agreement is attached as Exhibit A. The agreement specifies that defendant works for plaintiff within a work-for-hire arrangement regarding the copyright on defendant's contributions. The work-for-hire agreement means that plaintiff owns all of the copyrights to the defendant's contributions. Since at least sometime in 2016, defendant has asserted claims to plaintiff's copyrights in the Starmazer franchise and related content. Defendant has made these claims in violation of this agreement and in interference with plaintiff's business relationships and other rights. Since at least sometime in June 2017, defendant has asserted claims to copyrights on Starmazer-related content owned by both parties and non-parties. Defendant asserts these claims through writings as well as legal notices to third parties. Defendant has asserted over 70 false claims to copyrights on Starmazer-related content owned by both parties and non-parties. Most, if not all, of defendant's copyright claims come in the form of Dmca takedown notices. Defendant's claims almost always result in the content being removed from public access and view while the Dmca procedure is followed. Defendant's illegitimate claims have caused and continue to cause severe and irreparable damage to plaintiffs as well as non-parties by interfering with their personal and business relationships as well as their copyrights and other rights. Beginning in June of 2017, defendant began making threatening remarks and gestures towards plaintiffs Thacker and plaintiffs' counsel. These threats were delivered via email, Twitter, and direct message communications. These threats from defendant quickly escalated to express threats of murder, arson, and vandalism. Plaintiff's counsel's duty to warn was triggered, and the threats were reported to the appropriate authorities. Defendant was taken into custody on June 29, 2017 by said authorities for involuntary mental health evaluation. So count 1 is for copyright misrepresentation under 512F. That's the Dmca misrepresentation statute. Plaintiff Imagos is the owner of the copyright in suit on its properties titled Starmazer and Starmazer DSP, hereinafter just the works. Plaintiff's work is an original work of authorship. Defendant has asserted numerous illegitimate claims on plaintiff's works. Defendant asserts these numerous illegitimate copyright claims on plaintiff's works in violation of 512F regarding willful and knowing misrepresentations. Defendant knows, should know, or is willfully ignorant of her work-for-hire agreement with plaintiffs Imagos and Don Thacker. Defendant is liable for the actual damages of her illegitimate claims, and plaintiff will prove actual damages at trial. Count 2 is for breach of contract. Plaintiffs Imagos and Don Thacker entered into an agreement with defendant in March of 2015. That agreement is attached as Exhibit A, and I'll show that in a moment. This agreement expressly specifies a work-made-for-hire arrangement between the parties to the agreement. The agreement expressly requires defendant to keep plaintiff's confidential information secret. Defendant has knowingly and publicly claimed ownership to plaintiff's copyrighted works in breach of the agreement. Defendant has publicly revealed plaintiff's confidential information in violation of the agreement. Defendant has breached her duties to plaintiffs under the agreement. Plaintiffs have been and continue to be severely and irreparably damaged by defendant's breach. Defendant is therefore liable for actual, special, and extra damages to plaintiffs. Plaintiff expects to prove damages at trial. Count 3 is for defamation per se, which is a special kind of defamation. Defendant has made serious and public claims of ownership to plaintiff's copyrighted works. Defendant has made serious and public allegations of misconduct in plaintiff's business dealings. Plaintiffs have been seriously and irreparably damaged by defendant's false claims and false allegations of business misconduct. Defendant's actions constitute defamation per se under both federal and Pennsylvania law. Plaintiffs expect to prove damages at trial. Defendant has made public statements that her actions are the result of a contract dispute with plaintiffs. Plaintiffs have gone above and beyond to attempt to settle the matter with defendant for at least a year. Plaintiffs do not believe that defendant has a legitimate claim at all, but have still made numerous offers in settlement. Defendant has made false claims to plaintiff's property, sometimes obtaining property or rights to property by consent. Any consent by plaintiff was induced by wrongful use of actual or threatened force, violence, or fear, and under color of an official claim to plaintiff's property. Defendant has used her false claims to encourage more favorable offers of resolution from plaintiffs. Defendant has made direct threats of serious bodily injury to plaintiffs and their counsel. Plaintiffs' actions therefore constitute extortion under 18 U.S.C. 1951. Defendant's extortion is reachable civilly via federal and state extortion and blackmail law. Plaintiffs to prove damages at trial. And then I include our prayer for relief. Plaintiffs respectfully request this honorable court grant the following relief. 1. A temporary restraining order requiring defendant to cease all threats and intimidation efforts towards parties in and for the duration of the case. 2. A preliminary injunction to stop further illegitimate copyright claims from defendant during the litigation and trial processes. 3. A permanent injunction enjoining defendant from filing additional copyright claims against plaintiffs. 4. A declaratory judgment finding plaintiffs to be the legitimate owners of the relevant copyrights in their respective works. 5. A judgment for actual damages against defendant in amounts to be proven at trial. 6. A judgment for special and or extra damages against defendant in amounts to be proven at trial. And 7. All other relief the court may deem necessary or appropriate. And then, since I know you'll be interested in seeing this, here is the actual contract. This is the signed agreement between Imagos and Alex Maurer. There is no misinterpretation of this contract on Imagos' side. And then it's got this very important section here called Work for Hire, which expressly makes it known that contractor services are specifically ordered as a commissioned work for hire. Production company shall own all proceeds and results in perpetuity without limitation, etc., etc., etc. It also contains a confidentiality clause. Contractor agrees to maintain the secrecy of all of producer's information, confidential information, which comes into contractor's possession. And if I understand correctly, there has been some disclosure of confidential business information as well. There's nothing in here that says anything about Alex retaining rights. There's nothing in here that says that this agreement is entirely void if somehow Alex doesn't receive 100% of the funds that were promised. There is, frankly, no way that Alex Maurer has a leg to stand on in this case. In the hypothetical situation where Imagos did breach their contract, that doesn't give Alex any right to a copyright. It actually only gives her a right to sue in breach of contract and request restitution and recovery for the breach of contract, which is the appropriate remedy. This is what you're supposed to do when two people have a dispute over a contract. You go to court over it. the threats and this copyright claiming and the general acting out are not in accordance with civilized society and really aren't making her case look any better either in the court or in the public eye. So this brings me to a larger point that I want to make. Tools of litigation can be used with a heavy hand or as a surgical instrument. And what we're trying to achieve here is more of a surgical procedure than a carpet bombing, metaphorically speaking only, of course. This would be a negotiation tool that I've come to understand over the years, and I call this technique the graceful way out. It's not the gracious way out. It's not my graciousness in letting you out, although it is, but that's not what it's called, and that's not how you present it. You will benefit from it by being gracious, but what you must do, what you must achieve, is to give the opposing person a graceful way out of the situation. Our first week of litigation was mostly an attempt to give Alex a graceful way out of the situation. Get her some help. If she accepts the help and wants to resolve this situation, we were willing. Unfortunately, she very quickly rejected all attempts to resolve the situation. So that is why we have turned to litigation and will no longer be offering this level of graceful way out. Now I think we need to use the courts to establish our rights and go from there. So what are the next steps? Well, in the beginning of this thing, you may have noticed that this was a verified complaint, and that's a very important step because I'm about to file for a temporary restraining order or other relief in court that should move this thing along. And if this relief is granted, we will be seeing action from the court much faster than having to wait until Alex decides to respond in 3 weeks. Thank you all for your wonderful support for our fundraising campaign for this legal defense, or rather legal action. I guess it's a defense in one sense, but then we're the plaintiff in court, so you kind of have to look at it both ways there. There was a question about why the amount was raised from 10,000 to 15,000. It was always 10 to 25,000, and GoFundMe only allows you to enter one number at a time. So after we've reached an initial goal, I definitely increased it to 15. I have it hovering at 15 now because I think that's my estimate of what I'll need for this case if nothing else changes. The thing that changed that made me increase it from 10 to 15 was the whole threats section of this. That definitely took an enormous amount of my time and effort and will require additional effort as we go. If you would like to further discuss things, we've been having very active discussions on my Discord channel. You can find a link in the description below and click on that and grab the Discord app and click it again if it doesn't get you back in, and you'll be connected to our Discord. If you see the red Lawful Masses logo, then you know that you're in the right place. All right. If you are one of the people that has been affected by Alex Maurer, you are welcome to get in contact with me. I have a contact form on my website at leonardjfrench.com. That's the easy way, or you can wait for another update when I'll actually be asking for additional plaintiffs who want to join the lawsuit. And that's basically the update, is if you are affected by this, you can message me or you can join our lawsuit and I'll have more information about how you can do that. You do not have to hire me as your attorney in order to join the lawsuit. You can represent yourself or you can hire your own attorney. I will be happy to help to tell you how to join the lawsuit, or at least what rule of civil procedure you have to follow in order to do so if you don't want my advice. If you are not affected by the lawsuit, if you are just watching this with your popcorn and your soda and you're having a good time, with all of the interesting things that are happening and how they affect our copyright law. And if you enjoy all this discussion and all that, great. Continue to have the discussion with us. What I do ask specifically is that you don't take this to another level. I'm trying to make the point that we take disputes like this into court, that this is the proper and actually most compassionate way to deal with the situation, and sending any sorts of threats or anything to Alex for any reason, or even just angry letters, they're really not helping anything. All you're doing is adding fuel to the fire and giving her more and more motive to make things more and more difficult for everyone. So I honestly believe that my community is not the people who are causing any upset, but I wanted to make an affirmative statement, so consider that done. What should Alex have done? Alex should have sued Imagos if she really thinks that there was a contract violation. I do not believe that there was a contract violation. In fact, I believe there were at least 16 ways that this was done and over with before any money was actually owed to Alex. Any additional money was actually owed to Alex. However, assuming that Alex really, really believes there's a contract problem here, she goes to court. She files a lawsuit. There could have been 16 different places she could have filed a lawsuit, and Imagos and Don probably would have worked with her to resolve the matter. But she does not seem interested in a resolution that does not also validate her claims of copyright. And that's not something we're interested in, because that's obviously everything that the company has worked on for the last several years. So, what do you think Alex should have done, and what do you think I should be doing? It's YouTube. We have comments below. We have Twitter. You can respond on Twitter. You can come into Discord and tell us what you think, and I would love to hear your thoughts and comments. I would like to thank my Patreon supporters on my channel. That is Joshua Meinzinger, Baxorn, John Cripps, John Steele, Westin Lohne, and Nate Beck, who are supporting this month at the $50 level. I would like to announce that we have a new supporter. New Sensei is the first supporter to sponsor a video, and I'll have an announcement shortly about what will be produced in August for that sponsorship. Thank you very much, New Sensei. And all of my $5 plus supporters are scrolling on the panel behind me and in the description below. Thank you all, and all of the Patreon supporters who do not request a reward, thank you as well. You should be rewarded, and someday I will find a way to reward you with more than just a thank you message. But you are all wonderful people, whether you give a penny or a dollar or just send your love and regards. Sometimes it's all great to have all of that. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and I look forward to a great week with you all, and I'll have an update video for you very soon, I think. Thank you. A dream of creating a retro sushi.